Permit to mention one matter for inclusion in the list. Any other mentioning?
Original side listed matters. Item number 1.
This is appearing at my instance, my lord, for a minor correction in the cost title in the order, my lord, passed by your lordship. May I
Is
hand
the
over
corrected cost title to them?
just one spelling mistake, my lord.
Well, even following correction may be made. Correction or corrections may be made.
Grateful to your lordship.
Item number 2.
This is 34 application.
Intervention application. In my section 34 application, an intervention application filed by a company claiming themselves to be the original.
You have filed 34.
I have my 34. My section 36 is there. No, সেটা হচ্ছে 36. Because if that matter possibly is coming on after. Yes, the intervention application.
Rejection to deposit, that was in
section 36. That part.
Two cases were there.
Yes, one is mineral and the other is sugar corporation. For both, your lordship passed similar orders. In one matter, I think they have done it.
Yes.
The other matter will come up another day for the receiver registrar to file the report regarding the cash deposit made and the bank.
Those are 36.
36.
This is 34.
Yes.
34 and intervention is mentioned.
Intervention application is
GA-Com 1. Yes. Exchange of affidavit is complete?
Yes, everything is complete.
What last chance?
Parties are same. Punalur Paper Mills.
Yes, that is not
Award holder. Now, my lord, on the basis
that is
of
what
an
You are the award holder means Punalur.
Punalur. But on the basis of an agreement, we are claiming but the right to claim the compensation in respect of acquisition of the property has been vested onto us, not only by a registered deed of conveyance, but by a subsequent agreement also. So on that, my lord, I am also being led by Mr. Shaha, is there. My lord.
Yes, I'm there, my lord. Mr. Shen can address your lordship.
So on the basis of the registered deed of conveyance and an agreement, this right to receive the compensation money has been vested onto us because we have purchased the property at the time when the acquisition proceedings were pending in respect of the said
Where the property is?
near
New Market. This is a multi-story building at New Market.
So, based on that agreement, we have taken steps to pursue the proceedings. Ultimately, award has been passed on the basis of an order passed by the Supreme Court. Arbitrator was appointed. Then, my lord, the award has been passed. We have participated in the award and we have got the award now. Even before the arbitrator, they tried to intervene.
All right, let me hear Mr. Mukherjee.
This is
lordship
the background.
Yes. Yes, Lord, he has given a bit overview, but there are certain things, Lord, the main part which has been omitted is, Lord, that there was a power of attorney, Lord, in favor of my learned friend's client.
You want to intervene?
Because, Lord, I am the real Punalur, Lord, whose property was acquired by the state, and I am entitled to receive, Lord, the compensation. Now, Lord, kindly, Lord, we have prepared a short, Lord, compilation of documents. Lord, just to give your lordship, Lord, an overview of the facts. The compilation of documents.
Yes.
Your lordship will kindly come to, Lord, the first agreement. The first agreement.
First, you give me a short, very shortly, just tell me
yes.
local standing.
Now, Lord, I am the company. It is, Lord, a public limited company. Now, Lord, pursuant to an order passed by this honorable court.
What is your name?
Lord, I am Punalur Paper Mills Limited.
Then who is this?
Lord, the award holder Punalur is, Lord, my constituted attorney according to their, Lord, the claim.
Punalur Paper Mills is
Lordship.
the award holder.
Lordship.
And you are?
But I am Punalur. paper mills. But I'll tell your lordship, my lord, after your lordship, yes, my lord, it might be a bit confusing. Now, my lord, at one point of time, my lord, pursuant to the order passed by this honorable court, my lord, there was a sale, my lord, which was, my lord, affected in respect of, my lord, one of, my lord, the person who was, my lord, director at that point of time, and, my lord, his nominee company, my lord, purchased the property, which is the subject matter of, my lord, the acquisition. Now, my lord, it was stated in this sale deed that, my lord, that we have also, my lord, conveyed the right to receive, my lord, the compensation from this acquisition of the property. Now, my lord, this sale was effected sometime in 2003, no? 2003. Now, my lord, although, my lord, there is a covenant contained in the deed about, my lord, the conveyance of, my lord, the right to receive the compensation, but subsequently there was an agreement which was in the year 2010. On the basis of the agreement, my lord, we said that they will be receiving, my lord, the compensation on behalf of the company. That is, my lord, the first agreement that we have, my lord, appended, my lord, at pages 1 to 15.
That is an agreement between
Lord,
Punalur
that is
Paper
my
Mills?
client, and, my lord, my learned friend's, my lord, client who claims to be, my lord, the
Lindsay
power
Towers.
of attorney. Yes, power of attorney holders. My lord, now there is a change in the name. KHM Industries.
So there was an agreement.
There was an agreement. Now, my lord, your lordship will kindly come to the agreement, my lord, the main portion. My lord, why I say this agreement is important? Because this agreement itself is a proof that, my lord, that we did not want to convey, my lord, in the sale deed, my lord, their right to receive, my lord, the compensation, and they appropriated. It was on behalf of, my lord, my client, the Punalur, the company, that they were supposed to, my lord, get the compensation, my lord, obtain the compensation from the government. Your lordship will kindly come to internal page, my lord, 6, it starts. The preamble is there. Prior to April 2003, Punalur was the owner of the land and premises number 13 Neeli Sengupta Shodoni, Lindsay Street. Lindsay had duly purchased the said property being land premises number such and such by an indenture of conveyance dated 5th April 2003 registered at the Calcutta Registry.
This was purchased from Punalur.
Pursuant to the order of the court from my client, Punalur. The undermentioned various legal proceedings and or litigation were pending by on behalf of the Punalur challenging the acquisition and the requisition of the recovery of compensation, mean profit and other release from the said
Subsequently, it was acquired
property. Yes, this
by
is
state.
yes. Not a portion of the property, I believe, is similar subject matter of acquisition. Portion of the property. দুটো কোম্পানি আছে তো সুগার আছে আর একটা
In respect of second floor, my client was in possession. In respect of fifth floor, West Bengal Sugar Industry.
That is the other matter.
the other matter.
Portion was acquired.
First, that is possibly housing CDF, Calcutta District Forum.
No, not that. Not in this way. There was a Shomobaika, blood in the New Market Shomobaika was there. The Calcutta Wholesalers Consumer Society carrying business in the name of Shomobaika, 3 cases before the Alipur Court, West Bengal Mineral Development and Trading Corporation Limited, read petition number such and such, West Bengal Sugar Industries Development Corporation before Kolkata High Court. So, my lord, these are the legal cases which were, my lord, pending at that point of time, collectively referred to as litigation. Now, my lord, at page 8, the Lindsay had purchased the said property from Punalur by virtue of registered conveyance deed. The particulars are contained. Shall at all times be entitled to continue, prosecute, and or defend all or any of the said litigations and or proceeding thereunder, and also
Para you were reading out?
paragraph 8 at paragraph D at page 8. That about from 5th.
Got it.
Lordship.
Now, Lindsay purchased it from Punalur.
My lord. That's Punalur is my client.
You are Punalur.
I am Punalur.
Then who is Mr. Shen?
Lord, he is a purchaser and Lord, he now claims to be Lord, the power of attorney holder from my client. In the name of Punalur, he is Lord the alias.
The transaction. Punalur was acquired later by my learned friend's clients. My lord, Punalur always belonged to my lord someone else, my lord from whom my lord this property had been acquired. Then my lord, when it went into litigation, my lord, with regard to the challenge to the acquisition, etc., my lord, the company was acquired, my lord, by persons, my lord, who today, my lord, have authorized the other Mr. Mukherjee, my lord, to my lord appear for Punalu. But my lord, what had been left out, my lord, is my lord the compensation. That my lord, so my lord, it was my lord the power of attorney is coupled with a grant. Attempt before the arbitral tribunal failed. Attempt in the first round also, my lord, failed here. So, my lord, this is, my lord, what the position is. Now that we've succeeded in the acquisition and money has started coming in, my lord, therefore the intervention.
Now, my lord, the question here is, my lord, that who is to receive the compensation? Now, my
No,
lord,
go
is
ahead.
it that Mr.
You
Mukherjee's
continue.
lordship,
Lindsay purchased the
then, my lord,
property from Punalur.
Punalur. Now, my lord, thereafter, my lord, what it says, the agreement says,
So Lindsay became owner in the year 2003.
lordship. Now, my lord, whether Lord, that conveyance deed, Lord, permitted them to Lord that receive and appropriate. What I mean to say is that Lord, they can receive the compensation, remit it to my clients, the real owner, because Lord, the compensation is receivable in respect of the acquisition when my client was the owner in the property, not them.
So Lindsay will receive compensation.
And Lord, whether they should Lord convey it to my client, remit it to my client. This is Lord the bone of contention, entire bone of contention. They say that it is their property, the compensation. I say, no, you have only received on my behalf. You should convey and remit it to my client. So, Lord, the agreement, which was Lord, a letter agreement in 2010, it says, and also to receive, realize, and recover. There are three words: all compensation, mean profit, issues, and profits on account and in respect of the portions of the said property which have been subject matter of the said litigation in the name of Punalur, but at its own cost. So, Lord, if I, in 2003, Lord, intended to convey their right to receive the compensation, Lord, so far as Lord, they can appropriate it, I mean to say, then there was no necessity for my client, Lord, in 2010 to execute an agreement to say that you will be entitled to receive, realize, and recover all compensation.
This
Because
is the
if
very
I had-
agreement you relying upon.
Yes, thereafter, there are 2 or 3 documents. Your Lordship will find also, in connection with this, there were power of attorney which were executed, power of attorney which was revoked. Power of attorney revocation is subject matter of challenge in a suit, pending before this honorable court. Now, the question before your Lordship, that when the power of attorney admittedly stood revoked,
Just a minute. Then this clause 4 says, Punalur hereby agree and confirm that in case of realization of the amount towards compensation, the
Lordship.
same shall be exclusively belong to Lindsay, and the Punalur shall not be entitled to any right or claim.
Now, this is a subsequent agreement. This does not confirm, the right to receive and appropriate, as I say. Your Lordship will kindly, see, the other clauses that in pursuance of the understanding as herein before stated, Lindsay has so far
Paragraph?
been taken, paragraph E at page 8. Page 8, paragraph E. In pursuance of the understanding as herein before stated, Lindsay has so far been taking appropriate steps for realization of the compensation amount and mean profit, as also continuing to pursue.
You say in the name of Punalur.
Lordship.
That is
And
your
the
point.
proceeding, they are under in respect of the portion of the said property in the name of Punalur, but at its own cost. And then, the other important thing, the confirming parties above named, along with their nominees, have since duly purchased and are acquired equity shares representing about 52.76% of the total subscribed, issued, and paid up equity share capital of Punalur, has also acquired the control and management of Punalur and all its assets. Now, this agreement witnesseth that it is hereby mutually agreed, Then, my lord, I confirm, my lord, at clause 1, my lord, that they are the owner. Then, my lord, clause 2, it is also recorded that in pursuance of the understanding made at the treaty of the said sale of the said property is as hereinbefore stated, Lindsay has so far been perusing and prosecuting the said litigation and all proceedings thereunder concerning or relating to the portions of the said property, and also taking appropriate steps for realizing and or recovering the compensation amount and mean profits from the appropriate requisitioning and or acquisitioning authorities, and the same in the name of Punalur. In the name of Punalur. Punalur hereby agree that Lindsay shall at all times hereafter be entitled to pursue the said litigation and all proceeding thereunder, and such further or other litigations and or legal proceeding as also to realize the compensation amount, mean profit, other dues in respect of the portion of the said property, and the same in the name of the company and its own cost. Punalur hereby also agree and confirm that in case of realization of the amount towards compensation or mean profit or otherwise with regard to the portions of the said property, the same shall exclusively belong to the Lindsay, and the Punalur shall not be entitled to any right or claim of any nature thereto. Punalur hereby further agree that Lindsay and the nominee shall at all time be entitled to maintain and operate a separate bank account being number such and such with Mrs. IndusInd Bank Limited in the name of the company for limited purpose of receiving, realizing and encashing. But there is another bone of contention concerning this. Your lordship will be apprised about that litigation too. And other amounts as may hereinafter be received and are realized on account and in respect of the portions of the said property. The Punalur hereby also agree to grant power of attorney in favor of the said Lindsay and or its nominees, authorizing and or empowering him to represent Punalur, as also to defend and or contest and or prosecute all or any litigation and or legal proceeding, and further to realize the amount of compensation money, mean profit and other amounts, and to operate the said bank account for receiving, encashing and appropriating the compensation, mean profit and other amount, and further to sign, execute, affirm, verify and deliver all papers and documents, as also to do all acts, deeds, matters, things. And
Mr. Mukherjee, how would you reconcile these two paragraphs, para 4 and para 6?
Yes. Now, my lord, para 4 and para 6, your lordship will see, my lord. But if it was a conveyance in 2003 about, my lord, the right to receive the compensation, my lord, by, my lord, the Lindsay, I had no occasion, my lord, to execute, my lord, a further agreement empowering Lindsay, to whom I have conveyed, my lord, the property as well as the right to receive, my lord, the compensation. So, my lord, it was never the intention of the parties, my lord, that apart from the property, my lord, which was being conveyed to them in 2003, my lord, that we never wanted to convey, my lord, the right to receive, my lord, the compensation amount. That was always reserved with the company. It was only an arrangement in 2010 that, my lord, this agreement was executed that, my lord, they will, my lord, at their own cost, do everything to recover the compensation amount due and payable, my lord, to Punalur in the name of Punalur. In aid of such agreement, we agreed that we should be executing a power of attorney.
For doing those things.
Yes. So, my lord, all it that conveys that you do not have any independent right to realize that money and pocket it.
That
All
is explained
that you
in
are
para
doing
6.
it,
That
that is
explained in,
explicit in para 6.
and
Therefore,
for this purpose, this power of attorney was to be executed.
and that was executed.
But now, how would you reconcile para 4?
Now, my lord, the para 4 is, my lord, a straight statement. It does not even, my lord, and that Punalur shall not be entitled to any right or claim of any nature thereto, but doesn't, my lord, in unequivocal terms say that, my lord, the compensation amount is to be appropriated by, my lord, Lindsay. All that it says that, Lord, I will not be, apart from this money that they recover, I will not be claiming anything from Lindsay. That is my way of not viewing this particular clause. Otherwise, we cannot reconcile with the other clauses of the agreement.
Why have you introduced this clause?
But this clause was, my lord, just by way of an abundant caution, my lord. Otherwise, your lordship will kindly visualize one thing, that if they had every right, then I had no occasion, my lord, to execute an agreement, because they are the owners in 2003. Therefore, whether, my lord, their ownership right was also, my lord, with the coupled of with the right to, my lord, appropriate, my lord, the compensation amount. That is the question. So, my lord, going by, my lord, this agreement, which is, my lord, an admitted position subsequently, the strength on which, my lord, they have applied before, my lord, the authority for being implemented, and they, my lord, participated in the proceeding. They were doing so, my lord, in the name of Punalur, on the strength of the power of attorney.
What is in your pleading?
My lord, your lordship will kindly, my lord,
You must have explained your locus standi.
lordship. Number paragraph 3, page 3.
Paragraph 3.
3, page 3.
Yes.
Then, my lord, page 4, my lord, Roman 4.
Which paragraph you have explained this?
My lord, your lordship will kindly see, my lord, now, my lord, your lordship has seen, my lord, the order that has been passed by, my lord, the coordinate bench in, my lord, the civil division. I am the civil suit at page 9.
Page?
Page 9, paragraph, my lord, 15, Roman 15. I take your lordship, my lord, to that judgment, and thereafter, my lord, I take your lordship to the other statement. More particularly, my lord, paragraph 17 at that page. Backward.
You have cancelled the power of attorney.
Yes, my lord, that is the subject matter of the civil suit, which is pending here. And the order that your lordship will find at page 723, my lord, your lordship can see it later on, my lord.
So your point is, since power of attorney has been revoked,
Yes.
now you have the right. Your
Now-
right is revived.
I have a right, my lord, at least for the limited purpose here in the section 34, I have a right to be implemented.
Right to be heard at least.
Yes.
That is your point.
That is my point. I am not taking your lordship, my lord, to the other aspect of the matter. But here, my lord, whether, my lord, I am a necessary party and I have a right to be heard, my lord, in the section 34, because if there is any alteration to the award at the instance of my learned friend's client, my lord, it is my company who is affected. Therefore, my lord, going by the theory of affectation, my lord, even, my lord, it is my client.
You are
my lord,
harping upon, or you are relying upon this revocation of power of attorney dated 11th May 2021.
lordship, lordship.
All right. This is your point.
This is my point. So, my lord, if your lordship desires, I can give your lordship, my lord,
short
a
note.
short note giving the gist of the matter.
Yes.
Because, my lord, the entire aspect of the matter, my lord, in my respectful submission, may not be a consideration for the limited purpose whether I should be arraigned as a party or not.
Right. Give a gist of the whole things.
I will do that, Lord. I'll do that. But on the next day, Lord, I'll do that because
How long would you take? 7 days?
no, Lord, already my the learned friend has prepared one, but I think I have to go through it. Next week,
16th May?
as your lordship pleases.
What is the other date?
I অন্য date গুলো কবে আছে?
7th, my lord.
7th May.
That is in respect of section 36.
36 is 7th May. Heard Mr. Mukherjee, heard in part, adjourned to 15th May. Mr. Probal Mukherjee, yes.
Mr. S.L. Mukherjee.
Mr. Probal Mukherjee in part.
My lord, if the notes we can receive a copy, then we will be prepared to respond.
Yes, sir, Lord will give a copy Lord, to my lord. এটা আগে আমাকে দেখিয়ে তারপর ফাইল করুন। I'm grateful.
Item number 3 to 5 and 9.
I appear for the plaintiff. My lord was hearing this application. It's an application.
Possibly only part had,
Yes.
all the applications were part had.
Yes, my lord. GA4 was what my lord was hearing. It's the order 13A application. I'm seeking summary eviction. Mr. Dutt was my leader in the matter, my lord. He's concluded already. It was Mr. Bose, my lord. Last 2 occasions time has been sought. They were to prepare a note and file it before, my lord. We have already filed our notes along with the judgments, my lord.
This is my note, my lord. First, my lord.
May I get a
my-
copy, my lord?
Yeah, certainly. My leader is Mr. HON'BLE Bose. He be leading me. According to his instruction, I have been asked to first place the list of dates. That's list of dates. The part of the written note, my lord. First, the factual background leading to the filing of this application. The 1972 defendant.
This summary judgment is GA.com of 4 of 2025.
Yes.
So I'm hearing 4. What about other applications?
So the other application, there is one application, my lord, filed by my client for judgment on admission. That is a prior application. But if I succeed in GA4, my lord, that will subsume everything. And the
What is
last
the application number?
my lord, that is GA3, I believe. GA3. GA3 of 20.
They are maintaining 2 applications at the same time.
But my lord, GA4 is there, my lord. My lord is hearing for the time being GA4.
GA3 is there.
GA3 is
GA3 is not part heard.
there. No, it is not part heard. My lord is hearing GA4 for the time being.
Hearing
Right,
of that-
GA3. So I'm releasing GA3
My lord can do so. My lord can
because
do so.
I have no determination for hearing
Well, I
GA3.
can
It's
do
not part heard matter.
My lord can do so. But my lord, my only submission is, my lord, since GA4 is parted, if that succeeds or fails, my lord, thereafter, my lord can
Alright.
pass the necessary order.
All right.
Maintaining 2 applications for the same cause.
Yes, Mr. Datta.
1972, defendant required an office for its business purpose and approached the plaintiff. At that time, the plaintiff was a lessee of premises number 3H Shakespeare Sharoni, Calcutta, and constructed a ground plus 4 upper floors at the said premises and had no funds for making further construction. The defendant agreed to lend and advance a sum of rupees 1 lakh to the defendant so as to enable the plaintiff to construct the 5th floor of the building, and the plaintiff also agreed to grant lease of the entire 5th floor to the defendant as and when constructed. 72, everything started. 29 June 1972, 2 separate documents were executed between the parties. The first document was a loan agreement whereunder the defendant agreed to grant a loan of rupees 1 lakh to the plaintiff for constructing the 5th floor of the building. The second document was an unregistered lease agreement whereby the plaintiff agreed to grant lease of the entire 5th floor of the building to the defendant for a period of 10 years with right to obtain renewal at a consolidated rent of 5,110 per month. Clause 2II of this document provides that the lessor, that is the plaintiff, would pay municipal tax, both owner and occupier share, after the first assessment was made upon completion of the construction of the demised premises. December 1972, plaintiff, after completing construction of the fifth floor with the fund provided by the defendant, made over possession of the same to the defendant. In the absence of registration of the lease agreement dated 29 June 1972, the defendant became a monthly tenant of the plaintiff of the suit property under the plaintiff under the then prevailing West Bengal Premises Tenancy Act 1956. In short, 1956 Act at a composite rent of 5,000.
Not read out.
That's the rent. So just the factual background, Malo, is essential, Malo. March 1991, Mulchand Rampuria, who was looking after the affairs of the plaintiff company at the relevant time, had a discussion with Govindram Goenka, the deponent of the affidavit in opposition, for enhancement of the composite rent of the suit property to rupees 11,000 in light of the substantial enhancement in the municipal tax, common electricity charges and maintenance charges. Govindram's Goenka, on behalf of the defendant, agreed to enhance the composite rent to 11,000 per month, subject to the plaintiff providing certain additional services as enumerated in paragraph 4 of AO. Mulchand Rampuria, on behalf of the plaintiff, accepted the proposal of Govindram Goenka. On behalf of the defendant, had requested that the increased amount should be nomenclated as service charges so that the liability of the plaintiff on account of the municipal tax was not increased. 1995, plaintiff demanded further increase in the composite rent, but the defendant refused to enhance the same. Thereupon, the plaintiff gradually started creating obstruction in proper enjoyment of the suit property by the defendant. July 2000, defendant filed, that's me, filed CS number 273 of 2000 in the Honorable Court for framing a scheme for maintenance of the common areas of the building.
Whole defense rests on one point. Actually, according to you, the rent was 8029 per month. Coupled with municipal tax, it comes to 11,000 or something odd. So it will come within the ambit of Premises Tenancy Act. That's why this application is not maintainable.
Before we go to that point, we have a more preliminary point as regards to the maintainability of this application at this point of time. That's the reason I'm placing this. I will come to that point. The whether that application is at all maintainable at this juncture of the suit or not. That is the first point.
What are your grounds? What is your AO?
Well, just the facts, Mala.
Facts I've seen.
The 2 pages, Mala. Those list of dates is important, Mala. That's the reason I'm placing that list of dates, Mala. Because I will take your lordship that what was the stage of the suit. That's the reason. July 2000, I filed a suit. I filed a suit. I have placed that list of July. I will just place the list of dates and I hand over to Mr. Bose. Defendant filed a suit, in short, before this court for framing a scheme for maintenance of the common areas of the building for a declaration that the defendant is a monthly tenant of the suit property and for various other reliefs. The plaint of the suit is at page such and such, and the reliefs are at page such and defendant's suit is pending before this honorable court. July 2001, 1956 Act was repealed by the West Bengal Premises Tenancy Act, which came into force on this date. Section 45(2) of the 1997 Act provides that notwithstanding repeal of the 1956 Act, all suits pending at the commencement of the 1997 Act would be continued and disposed of as if 1956 Act had continued and 1997 Act had not been passed. Defendant's suit is therefore to be decided as if 1997 Act has not been passed. 16 July 2011, plaintiff issued a purported notice seeking to terminate the tenancy of the defendant over the suit property upon expiry of 15 days from the date of receipt of the notice by the defendant. August 2011, plaintiff filed the present suit in which this application is being filed. Present suit being CS number 189 of 2011 against the defendant for eviction of the defendant from the suit property. The plaintiff of the present suit is appearing at such and such page. November 2000. Now, these 4 dates are very crucial. November 2011, plaintiff defendant filed its written statement in the present suit and clearly stated that the monthly amount of rupees 11,000 payable by the defendant to the plaintiff comprised of rent under the 1997 Act, occupier share of the municipal tax, as also the maintenance charges, and consequently the rent of the suit property under the 1997 Act was much below 10,000 per month, and the defendant was entitled to protection against eviction under the 1997 Act, and that the present suit was barred under 6(4) of the 1997 Act. The written statement is appearing in such a statement. Now, 4th July 2016, Honorable Justice I.P. Mukherjee framed issues in
Mr.
the
Dutta, I have seen all these things. Come to your point.
Kindly take this to mark this points, my lord. 4th July, 18 July, and 9th August 2016.
Yes.
This 4 dates, my lord, issues were framed.
Subsequently, issues, since two suits were subsequently taken up together, these
and
issues were different.
recalled.
Recalled.
It's a suit at the stage of trial. Now, thereafter, Mr.
So issues are yet to be framed.
Issues were framed. The day came up. Now,
What are you doing with this? What are you doing with this mobile phone? Why it is flashing? Please go outside. It is disturbing. Please go outside.
With your lordship's kind leave. Well, the reason why we placed the list of dates was to show your lordship that there have been issues in the past where certain coordinate benches felt that this is a suit which should be heard by taking evidence. Issues were also framed. Thereafter, it was recalled, and there have been a whole lot of litigation by which two suits were directed to be heard together. And it is only when we got an order from the court in which my suit was...
Where is that order?
It is referred to in the...
Page number 146 of?
Well, that is not this is the order which recently I showed to your lordship, on the basis of which my lord has been pleased to add my suit also in the list, which is appearing as item number 9. But that is neither here nor there for the moment. Today, your lordship has to see whether this order 13A application, which has been taken out by my learned friend, is to be heard, and any orders should be passed thereon. Now, the principal rule which guides all courts, my lord, and I say this with the deepest of respect, and hearing matters under Chapter 13A or Order 13A, is whether there are disputed questions of fact involved, whether evidence will be involved. If your lordship feels that there are disputed questions of fact and law, in the other application of mine in Ajay Agarwal, your lordship is pleased to observe, if there are disputed questions of fact and law, then obviously the suit has to be tried. Now, the reason for preparing this list of dates and adding it to our notes of arguments was to show to your lordship that disputes exist right from the beginning, and certain coordinate benches had already framed issues to which they had agreed. Thereafter, because affidavit written statement was not filed, my lord, the order was recalled, and the issue will have to be framed all over again if my lord is pleased to say that the suits have to be heard by leading evidence. Now, therefore, it is not just a question of fact, it is also a question of law.
Mixed question of law and fact.
Yes, and also a question of propriety, because certain courts before your lordship have already held that the suits should be heard together. Issues had been framed, thereafter recalled. And finally, my lord, the courts have said the suits have to be heard and tried. Now, the main point taken in the Order 13A application is that we have admitted that the monthly rent is 11,000 rupees per month. Since the monthly rent is 11,000 rupees per month, the tenancy is governed by the Transfer of Property Act. We have received the notice under Section 106 of the Transfer of Property Act, and therefore,
is there any tenancy agreement?
It is all there in the documents.
With this application?
My lord sees, I've explained it. Kindly see, take my notes of argument which has just been handed up.
Written submission on behalf of the defendant.
Yes. The instant application for summary judgment under Chapter 13A is not maintainable and liable to be dismissed in limine for the following reasons. Order 13A, which provides for summary judgment, was inserted in the Code of Civil Procedure with effect from 23rd October 2015. The plaintiff did not take any step for getting the suit marked as a commercial suit within a reasonable time after enactment of Order 13A. The instant suit is marked as a commercial suit by this court in May 24. So, my lord, 2015 to 24, nothing happened. All the 13A stood enacted with effect from 2015. The plaintiff proceeded with the trial of the suit in the year 2016. On 4 July 2016, this court was pleased to frame issues at the instance of the plaintiff. And on 18 July, the plaintiff filed affidavit of evidence of Vinod Rampuria. Even that was filed. Next. Since the plaintiff was seeking to steal a march upon the defendant by proceeding with the trial of the instant suit by totally suppressing the factum of the defendant's suit, I have a prior suit where I've asked for a declaration that I'm a tenant. This honorable court felt that both the suits should be heard analogously. In that view of the matter, this honorable court, by an order dated 9th August, cancelled the issues framed and directed that fresh issues to be framed after discovery and inspection. Naturally, both the suits have to be taken together. The order dated 9th August clearly shows that this honorable court was inclined to hear both the suits, the defendant's formal application for analogous hearing, and for framing one set of issues for adjudication of the suits is pending before this honorable court. In the aforesaid background, this honorable court may be pleased not to hear the instant suit independently and or individually. The proviso to Rule 2, Order 2 of the Order 13A provides that no application for summary judgment may be made after the court has framed the issues in respect of the suit. Of course, it was recalled. I say that, but it had been framed once. Trial of the suit having commenced in the year 2016, the application under Order 13A for summary judgment is not maintainable and is liable to be dismissed. Then, my lord, I have talked about my affidavit in opposition. I did not place that. Kindly see my defense. This is where I talk about the agreement. And if my lord reads my defense, my lord will be pleased to come to the conclusion that all this has to depend on evidence being granted. In the written statement, the defendant has categorically taken the following defense. Defendant was inducted in the suit property in pursuance of covenants contained in an unregistered indenture dated 29 June 72. Clause 2.2 provides that the lessor, that is the plaintiff, will bear, well, this is the important part where evidence will come in, the entire municipal taxes both owner and occupier share, and the defendant would be liable to pay only the future increase in occupier share of municipal taxes. The agreed monthly rent under this indenture is 5,110. According to me, this is the rent. In other words, the agreed rent of the suit property included tenant's share of initial municipal taxes, and the defendant was obliged to pay only increase in tenant's share of municipal taxes in future. 5,110 initially included the occupier's share.
So according to you, these are mixed question of law and facts, cannot be decided at this stage, and you have a fair defense.
I have a fair defense. I have given, my lord, just to assist your lordship, the dichotomy in the law which might also come in and which will have to be discussed. I've handed over a copy of these notes to my learned friend, where I have discussed the concept of rent under the 56 Act, under the 97 Act, and even under the Municipal Corporation Act. And we have tried to show, which we will show by leading evidence, and my lord, referring to the definitive sections in those three acts, that these are things which have to be heard in detail by your lordship after taking evidence.
All right. Anything else to say?
But we'll reply to this notes, my lord. Let us consider and come back on another day just to reply to this notes, my lord. It's just been handed over.
Friday?
My lord. Yes, my lord. Friday, no issues. Or my lord can keep it next week, my lord. It would be better. My lord, apart from Monday, any day, my lord. If it commences tomorrow.
Heard in part adjourned to 7th May.
Obliged.
Heard GA3 of 17 in part.
GA4 of
4
of 24, my lord.
GA 4 of 24 in part.
Obliged.
I'm very grateful. My lord, I have purposely not, my lord, really tried to distinguish the judgments which he has made and all.
The judgment, what you say?
It's a part of my notes, my lord. It's annexed.
Notes টা দেখে
From the notes which I've made and the definition of rent and the breakup of the rent that I've given, my lord, it is trite law to submit before your lordship that once notice under 106 is given, yes, a suit will lie. But the question is, are you calculating the rent on the basis of the components of rent? How does this 11,000 come below 10,000?
here the very basic point is that it's a question of fact.
Yes, I'm very grateful, my lord.
Which para you are referring to in this argument?
My lord, I just indicate what my lord, which judgment is my lord referring to? We've referred to my lord the paragraphs. My lord, total my lord 3 judgments we're relying upon. Firstly, my lord, the decision in Pile Vision, my lord, primarily. Pile Vision, my lord, the Supreme Court categorically lays down that once receipt of 106 notice is admitted and the fact that the rent or rather the tenancy is not governed under the Rent Control Act is admitted, my lord, a summary decree for eviction is a matter of course. That has been affirmed also by a division bench of our honorable court. No, that, my lord, we are
Like,
referring
let me hear.
yes. My lord, that our argument, my lord, will recall. Our argument is
And in Apollo GPER, which paragraph you are referring to?
my lord, Apollo's. I think that is only for the component of rent, my lord. Alin,
62.
62. I've already placed, my lord, last occasion. We'll just reiterate, my lord. My lord, if I may sum up my case in very short, my lord. I was being led by Mr. Dutt, my lord, who'd already made his submissions. My lord, the case is, my lord, today the defendant in this suit, my lord, has admitted that the rent is 11,000. Even in the list of days has been handed over to my lord, the rent is admitted to be 11,000. That is above the statutory limit of 10,000 rupees.
I have given the
Then-
components of that 11,000.
Yes, my lord, but the only fallacy there is, my lord, not only has the defendant admitted the rent, the defendant has also paid TDS on the entire component of 11,000 rent, and that is annexed to my application. That is the main bulwark of my
All right.
argument, my lord.
Got your point.
Yes.
Come on the next date.
Yes.
I will reserve for order.
No, my lord will hear us and then reserve it for on the next day.
Yes,
Yeah.
on the next date.
Publish.
এটাকে একটু ইয়ে করে দাও না, বানিয়ে দাও।
Deeply affectionate. Well, item 9 also.
Item 9 also.
Item 9 is my learned senior friend's suit, which has been specially assigned. That was normally appearing on the same day. My lord can adjourn it also to that date. My lord will not tag it. That's
All আচ্ছা ওখানে 9টাও করে দাও, 9ও অর্ডার করে দাও, adjourn to same date.
act out of the
Item number 7, Lolit Kumar Bed. 2 p.m. 2 p.m. Item number 7,
May please, Your Lordship. Your Lordship will recollect, this is the suit where a decree has been passed on a deed of settlement. Lordship, on the last day, there was a report of the assistant registrar that there are some defects, Your Lordship. Your Lordship was gracious enough to hand us a copy of the defects of the report of the learned assistant registrar. Lordship, some of the defects, some steps had already been taken before the decree department, and the other defects that have been pointed out will possibly can be answered from the deed of settlement itself. Your Lordship takes the report. The first defect Your Lordship will find
I will check it. I will go through the report. I will talk to the department.
Lordship, some
এটা
indication,
চেম্বারে দিও।
some indication might be required. And if I Lordship allows
I
me
will
to
talk to the department. The চেম্বারে দিও।
item number 8, item number 8, Joy Rajendra Impex Private Limited.
অর্ডার শিটটা দাও। None appears. Full stop on previous occasion, namely on 8th April 2025, also none appeared, that this would be dismissed for default.
Item number 10, John Augustine.
My lord, this is my suit. But I'm led by Mr. Mukherjee.
I'm leading, my lord, Mr. Bhattacharya. My lord, there was an interim order, my lord, which had been passed. My lord, it's expiring, my lord, today. My lord,
The
an
appeal is pending.
the appeal is pending, but the bench, my lord, is not sitting today. My lord, it was to conclude today, my lord. The learned
Give a short extension, my lord.
kindly give a short extension, my lord, and my lord, it will.
1 week or some more.
Yeah, no. Kindly make it 2 weeks, my lord. আরে
Oh, okay.
আরে একদিনই তো উড়ে যাবে তো ওখানে উড়ে গেলে আরো
With liberty to mention, making it for 2 weeks with liberty to
well.
mention. Since the appeal is pending, hearing of GA 1 of 25 is adjourned to
1 week, ma'am.
8th May.
ছুটি
ঠিক আছে, 8th May.
Ad interim order is extended till date.
প্লাস
11. Item number 11.
My lord, I'm praying for a short Passover, my lord.
Item 12.
This is the
What is GA3?
GA3 is for amendment of the asset, the affidavit of asset in the probate proceeding. I'll tell you the brief background, my lord. Lordship has called for a report from the registrar. In GA3, we have sought for amendment of the affidavit of assets, which are page asset which is page 45, other proposed amendments. Now, after the probate has been granted by this honorable court, my lord, we discovered
Following assets, namely share.
shares. Shares at page 45, Aditya Birla Capital Limited shares,
Mahindra and Bosch.
Mahindra and Bosch. These three
Only
shares.
to include the shares.
I want to include the shares. Probate has already been granted. The probate granted.
Now, what is this?
The
Will.
Today's application is only
No,
for.
where is the will?
No, will is page 21. I'll just tell you the background because the background is.
Let me go through it.
Yes, ma'am. Will is at page 21. Now the will.
21 is power of attorney.
No, my lord. But page 21 annexure, page 21 of the application is the will. Charles Herbert Heap of Pan's Garden. I bequeath the sum of rupees is given to his wife, my lord. This is the will of this gentleman, my lord, which was executed in London. He had some properties in India. Under this will, my lord, the Dutch will can execute it over there. Now the two executors are mentioned over here. The executors under the trustee we mentioned in the first paragraph of the will. The appointment. Now this will, followed by a codicil, which is at page 25. I'll come to that, man. I'm aware. The report. Yes, I'll come to that. It's a bit of complication, I know. So this will, followed by the codicil, page 25. Now this will was probated by the Family Division of England. I've annexed it at page 29. That was probate was given. Now thereafter, under section 228 of the Indian Succession Act, if a probate is granted by a foreign court of a will, you can put the same document in a court in India in respect of the properties in India. So that was done. So after the probate was granted by the English court, the same document was brought before this court and another application was applied before this court, and this Honorable High Court has granted the LA, grant of LA at page 56. And here the properties in India are part of the asset, which is shares. which are mainly the shares of the Indian companies. Page 56. So this honorable court at page 56 has also granted the letters of administration in favor of the executors. Now, so far the executors are concerned, the executors did not apply. Under 242, the executors have the power to give a power of attorney holder to an Indian counterpart to apply for that. That was done. Probate was, everything was obtained. Now we discovered the shares of these three companies got missed in the affidavit of asset. Now, on scrutiny, we added this. On scrutiny, from your lordship, that notice to be issued to these three companies, whether they have the shares in my name. Now we discovered which their pleadings are there. So far as supplementary affidavit I have prepared, my lord. Lordship has granted me a leave also in the last. Lordship will kindly see. I'll just read my supplementary affidavit. Now, paragraph 6. This Charles Herbert Heap was a customer or a client of CFS. The CFS is a paragraph 5 now refers to Senbank Financial Services Limited, which is a wholly owned subsidiary of Central Bank of India. They provide us with this trusteeship services. So these shares, paragraph 6 I have stated, my lord, so far the 9140 shares of Mahindra & Mahindra and 600 shares of Bosch are kept in CFS in the name of CFS to the credit of the estate of the deceased. And so far the Aditya Birla shares are concerned, they are in with the...
Then how this will, codicil can be amended? How this will, affidavit of asset can be amended?
Yes, the difficulty is, my lord, unless now she will kindly see what these companies are saying. The shares are in this trusteeship company in the estate of the deceased. Unless these are part of the asset, they will not transmit the shares. That is the difficulty.
I understand, but these shares are not in the name of this person, the testator.
The shares are not in the name of the testator, but that is the thing. She will kindly...
I understand some difficulties we have. But some
is it-
others' property,
No,
basically.
not the others' property. It's a trusteeship. So this CFS, she will see page 8 of my app.
No, sorry, this cannot be done, I think. I don't think this can be done.
But page 8, this is a central government company
Maybe.
of the Central Bank of India who provides this trusteeship services. I've annexed what service they do. They are the wholly owned subsidiary of Central Bank of India. They give trusteeship services, which includes executor trusteeship, debenture trusteeship, and escrow trusteeship services. So, and there's a letter, Malad, I'll show you that page.
So it is a liability of this company.
This company to hold the shares. The difficulty is in earlier days.
Who is the executor?
These are the companies.
Who is the executor?
Executors are mentioned in the will. The executor's name is mentioned in the will. What happened, Malad? In the
So
English
there must be some transaction between executor and this
not
company.
the executor, the deceased. I'll tell you, just give me 1 minute. What happened, Malad, in those days, in the British period, when the Britishers used to come to India, they have purchased some properties, shares, debentures, scripts, or they used to sail back to America or whatever their country. So they had these companies were formed, so they become a custodian of these shares. They can maintain these shares in India, so that they don't be logistically goes back to the England for safekeeping. So the share scripts, because there were scripts, the share scripts were kept with these trusteeship companies.
That is between the estate and this company.
Yes.
I cannot allow this amendment. Sorry.
Now, Malad, so far, unless this amendment is allowed, now
You have to look for some other remedies.
now
Peruse the report of the learned register.
Possibly then so far one share is concerned, that is in the name of the company. So far, Aditya. So far, Aditya Birla is concerned, Malad, that is
Mahindra intimated that there is no share in the name of the testator.
Yes.
Bosch intimated no share certificate in
So
the name
these
of
two are in the CFS. These two are in the
Safe
name of
intake.
Yes, Take Infect is the name of that is in the so far the Aditya Birla is concerned. Take Infect is the transfer agent.
Yes, this can be done only.
This can be Aditya Birla. Now, Malad, so far, now Lakshmi, kindly come to page 9 once of my supplementary affidavit, which is also in my petition also. So this is the letter being issued by the Central Bank of India, which is the Central Bank of India's wholly owned subsidiary issuing this letter. But this is the subject, estate of Charles Herbert Heap. Now it's referring, we note your claim of 9,000 shares of Mahindra & Mahindra and 600 of Bosch.
You fight between the itself. File a suit against them or do whatever you need to. Because while probate has already been granted, affidavit of asset, I have to decide some list or decide some rights of the parties. This can be done only. Peruse the report of the landed register original site dated 21st March 2025. It appears from the report that Mrs. Mahindra and Mahindra Limited as well as Mrs. Bosch Limited intimated to the landed registrar that no share certificate is there in the name of the testator. Full stop. However, Mrs. K Fintech intimated that there are certain share certificates, certain shares, not certificates, certain shares standing in the name of the testator, details of which are contained in the report itself. Therefore, the proposed amendments.
Lordship, I'm interrupting, sorry, my lord. But will one letter for my page 10 of my supplementary affidavit. There, the central bank is writing, my lord, that we are holding these shares. We are holding the shares in the estate of the deceased. Page 10 of my supplementary, the letter which has come from the central bank. We reiterate that we are holding 909,000 shares of MMN and 600 burrs to the caption subject. The caption subject is in the estate of Charles Hebert Heap. So they say they are not the owners. They are holding these shares towards the caption subject. Now they are only the custodian of these shares. This central bank. Now, if Muller's pleasure, the another thing we can subject to Muller's pleasure, we can issue a notice to this authorities Muller also, whether they are the owners or they are only a custodian.
We propose for
Yeah.
Mr. Mitro, the learned senior counsel, next para refers to annexure page 10 of the supplementary affidavit and submitted that Saint Bank Financial Services, in terms of the letter dated, in terms of the email dated 9/4/2025, intimated that their custodian of 9104 shares of Mahindra and Mahindra Limited and 600 share of Bosch Limited full stop. The learned register original site shall submit a report as to whether Mrs. Mahindra and Mahindra Limited is holding 9104 shares of.
No, I'll tell you. Maybe serve notice to this CFS directly. The central government company. Liberty be given to me to serve notice to CFS directly. Let them come. The address is here, Malad. Saint Bank. Third floor.
Of Mahindra and Mahindra Limited
MG
and
Mark.
600 shares of Bosch Limited
Let me serve notice to Saint Bank.
are held by Saint Bank Financial Services Limited as a custodian of the estate of Charles Herbert Heap. Full stop. If it is so, the particulars of the shares shall be furnished in the report. Full stop. Necessary communications may be made by the learned register original site with the Saint Bank Financial Services Limited. The report,
Liberty be given to us to also inform the Saint Bank, Malad, if in the
report shall be submitted on or before the returnable date, that is 20th May.
apply.
Item number 13.
Lordship, I am appearing on behalf of the applicant. Lordship, on the earlier occasion, special officer submitted a report. I have also been served. Lordship directed to the registrar to provide the name of goldsmith. And in view of that situation, Lordship, under impression that the gold available in the locker to be assessed and valued by the goldsmith.
No enlisted goldsmith is there with the original site. So we have to look for some other else, someone else, or ask for some information from SBI or other bank, specialized bank.
One thing can be done, Lordship. I, being a advocate on record of this application, can weight the gold available and can make an approx value thereby, because third
No, let the goldsmith be appointed.
Privately.
Not privately. I will ask to the State Bank of India to furnish any empaneled goldsmith name. That can be done. In another matter, I have done that. Or you name some goldsmith.
Because local goldsmith is available.
No, you have to name someone.
At this stage, I am not aware that this situation will arise. Then, Lordship, I will take 2 days or 3 days time. Next Monday, I will provide the name which is locally available over there.
Not this week.
I was appointed for the special officer. I was appointed as special officer.
All right. Not this week.
My lord.
Item 14.
I appear for the plaintiff.
I appear for the defendant, lordship.
That application.
An application was filed.
What do you have to say?
Lordship, I'm taking the point of section 36. Lordship, once it has been admitted, Lordship, it is not so, my lord.
No, Justice Datta's, read Justice Datta's judgment very carefully.
Lordship.
There must be some judicial order.
Lordship.
If such order is not passed, where is the order? Last order? Then it will be deemed to be postponed. Adjudication is deemed to be postponed. No, not this order. When this document was admitted in evidence, was there any order?
No, but it was in evidence. At that point of time, Lordship, it was proceeding ex parte. So,
Right.
that is my first point.
But when the
The
document is
once-
insufficiently stamped and that is produced before the court,
Lordship.
if court doesn't pass any order, any reasoned order, then
For every Lordship document, no reasoned order is passed. It is exhibited.
so far as unstamped document.
Had it been, they raised an objection.
No, that is not applicable here.
Should we-
That judgment makes it
Yes,
clear.
Chip kindly comes to paragraph 21 of the judgment, which I have placed before my lord. It specifically states. Paragraph 21, Lordship.
Yes, that's what I'm speaking
Presiding
of.
officer- Yes. It says the presiding officer of a court being authorized in law to receive an instrument in evidence is bound to give effect to the mandate of section 33 and 34 and restrains.
Once a decision is obtained, when a decision is delivered, whether right or wrong, that is the point.
And even in the absence of any objection, Lordship, it specifically states.
It is irrespective of objection. It is not objection specific.
No, what my learned friend is saying, Lordship, I'm answering.
Irrespective of whether objection is raised or not.
Irrespective.
The question of
It can-
admissibility has to be
anytime
decided.
It can be raised.
I will
Lordship,
pass order. Next week.
my contention, Lordship, will consider the two contentions. Number one, this judgment, Lordship, previous to this judgment, there were several other judgments of the Honorable Supreme Court which said that once it has been admitted, it cannot be put into question again.
Those are
Lordship,
considered.
those were, Lordship, they were considered. Well, that's why, my lord, if at all this judgment is to be considered, Lordship, that has to be done in terms of, with respect to documents which, prospectively, my lord, for all the suits, Lord, that will create catastrophe, my lord. All the suits which has happened till date, for all times, Lordship, that,
All right,
that
I
is-
will pass the necessary
Lordship,
order.
that is number one point. Second is, my lord, it was ex parte, my lord. They chose not to appear before your lordships. They were
Your point is they have waived objection.
Lordship, they have no right to object as of now.
All right.
Lordship will consider these 2 points. my lord.
চেম্বারে দিয়ে দিয়ে অর্ডার করে দেবো।
Please, Lord.
Item number 15.
But in 15, but I am for the plaintiff, my lord.
I
But
appear
my
for the
suit for
defendant.
recovery of money. But we
What
have
is
also
GA4?
got an application under Order 12, Rule 6, my lord, in view of the admission made by the defendant. my
My
lord.
lord, I must admit, my lord, I'm in default, my lord. I require some more time to file my affidavit, my lord. Only 2 weeks. First extension. It's the first time I'm seeking an extension.
Accommodation is prayed for by the learned counsel for the defendant
Defendant, my lord.
to file affidavit in opposition. The same shall be filed within 2 weeks.
Obliged.
Affidavit in reply, if any, within 1 week thereafter. Let the application along with the suit appear in the list on 21st May.
Obliged.
I'm for the defendant in this matter. Earliest occasion, Lordship has directed to complete the inspection and discovery of documents.
Is it done?
Lordship, it is still pending. We'll seeking some time to finish the
Time is extended for inspection, discoveries, inspection, admission, and denial of documents till 13 June.
That's all.
— 17 and 18.
But 17, 18, my lord, is that matter, my lord, 2 suits.
Your Lordship, I appear on behalf of the defendants, Your Lordship.
Second item, my lord, I have an application for judgment upon admission, my lord, if your lordship recalls.
Why are you troubling me? I'm not supposed to hear this suit.
Oh, your lordship, part heard.
Yes, I will release it.
It was part heard, I believe, my lord, and it was
Part heard. CA is part heard. There is no argument in CS. Only GA was part heard.
GA is not the judgment upon admission. Once that is heard, my lord, and disposed, then the suit only, my lord, gets decreed. Because it's a
Is the other side.
admission. My lord, Mr. Jishnu Shah,
Your Lordship,
it took time, my lord, for the last 4 occasions. Very difficult now to, my lord, answer the client. Your lordship understands. We completed our arguments, my lord. Short point, 2 partners, 1 dies, no suit for accounts for 3 years. Clear admission.
Yes, I can remember this.
Yes. My lord, I don't usually oppose because Mr. Shah is a senior.
I'm giving a short time passover with if none appears on that date.
Your Lordship, I appear on behalf of the defendants, Your Lordship. Mr. Shah is out of station, Your Lordship. I'm humbly praying for an adjournment today, Your Lordship.
We have completed arguments on judgment upon admission. Your Lordship's pleasure was that the other side.
Basically, my pleasure was is to release this. Because this is not of my determination. Only the application is part heard. Got my point?
Release by delivery of judgment. Either way.
Anyway.
My learned friend will indicate a firm date when he wants
8
to
May.
do it.
I will hear it on 8 May.
Yes.
If you are able
Alright,
to
Your
submit your arguments, Jishnu Shah কবে appearance আছে দেখো তো?
3 adjournments on the
15th May. He is supposed to appear here.
I request my learned friend, only request him to finish on that day.
Obliged. We shall.
Adjournment will be allowed. The adjournment allowed is a peremptory. On prayer of the learned counsel for the year for?
Item number 17.
He is not a part of this application.
No, I am saying that both the applications are heard together.
No.
After this.
No, your Lordship has heard.
No, I cannot do that.
Saying this for
Only GA13 is part heard. Other matter.
GA13 is not part.
GA 960 is part of which is GA 5.
I am saying that after that, let it be.
After that, I will not have no determination. I have no determination at all.
Same thing he has said, my lord, last.
Which you are speaking of GA13.
Says
my application.
It's in another suit. And your lord, it's in another suit.
Couldn't suit your lordship, but
yes, please.
That suit I cannot hear.
Yes.
That is CS 195 of 2010. Not within my determination.
Since Mr. Chaudhary's application was being heard first, so your lordship has said that.
I am releasing this suit because this suit will not appear in my court. Even I need not release it officially or formally by any order.
Yes, it just need not appear in the list
Yes.
on next day. Only GA5 will come before your lordship. GA5 of 2018, old number GA.
Where is GA5?
My lord, it's a part of, my lord, item number 18.
No, CS 510 is part heard. But this is not part heard matter, GA5 of 18.
No, there is an order.
Mr. Chaudhary's application is part.
I have completed my arguments. It's part of.
Is it written anywhere, part heard?
Yes, in order my learned friend has seen.
Fix, कभी बोललाम date টা? 15th. Fix 15th May for hearing GA5 of 2018. This application along with the suit CS1 95 of 2010 as well as CS 510 of 93 shall appear together. I will pass necessary order on that date.
Yes, sir. And my lord, your lordship's observation about, my lord, no further adjournment and peremptory.
Adjournment given is peremptory. I will reserve it.
Yes.
19.
It should appear in the list in the second half.
No, this is another suit where the discovery inspection directions were given. Plaintiff has not done any discovery inspection.
Who is the plaintiff? Mr. Mitro.
Mr. Mitro will be there. I presume this is the first time the suits come in. On the last day, last occasion, your lordship passed an order for discovery, but we haven't got anything from. We had filed our written statement.
Mr. Mukherjee was there. Sarvapriya Mukherjee. None appears for the plaintiff. Learned counsel for the defendants are present. Time is extended for discovery, inspection, disclosure of documents, as well as admission and denial of documents. Till 16 June.
Grateful.
Lordship, I am appearing for the defendant number 1.
I am for the plaintiff.
Yes.
Last day, someone was served by publication, and I filed the affidavit service.
How many defendants are there?
They are not 13.
You are for State Bank.
Plaintiff.
Lordship.
No, the service will not upon.
You are plaintiff. You are plaintiff.
I am plaintiff.
And you are for the State Bank, defendant number 1.
Lordship.
So far as other defendants are concerned?
Only Milord 1 and 3 has filed the written statement. The State Bank has filed the written statement and.
Reporters call for.
Yes. 1 and 5 has filed the written statement. No other has filed.
Report of the learned register original site dated 21st February 2025 may be kept in record. Full stop. It is in the report that defendant number 13 and 14 have not entered appearance till 10 to 25. Full stop. Defendant number 4 has entered appearance on 5/9/2022, but till today has not filed any written statement. Let this suit be undefended against defendant number 12, 13, and 14. Now, discoveries inspections.
Kindly give me some time to discover document.
The learned counsel for the plaintiff seeks for an extension of time for discoveries, inspection, and disclosure of documents. Full stop. The time is extended till 17 June. Suit will appear in the list on the same date.
I have filed an application for amendment of the plaint. To meet appearing.
That is supposed to be appear in the list.
GA number 5 is not appearing. Meet appear in the list because the substantial amendment is sought for the.
GA 5 of
2025.
5 of 25 shall appear in the list on 5th May.
I am grateful to yours.
Grateful, Your Lordship.
সুটের সঙ্গে থাকবে না, সুটটা ইন্সপেকশনের জন্য থাকে, ইন্টারলোকিউটর আলাদা করে নিয়ে নেবো। ওখান তো একটা এফিডেভিটের অর্ডার দিতে হবে যদি হয়।
No.
21, you are in
Your
21.
Lordship, I am appearing on behalf of the plaintiff, Your Lordship. Your Lordship.
Inspection on 2 days, my lord.
2 days they have taken inspection, Your Lordship.
Almost.
Is it a commercial matter?
No.
No, Your Lordship. Only 76 documents have been inspected, Your
Out of
Lordship.
400.
Your Lordship, my humble prayer was that Your Lordship will kindly ask them
Before
to
that,
take.
please ascertain whether it's a commercial dispute or not.
No, it's not a commercial. Because this point was raised
Was-
before your lordship, you know,
This application was moved and was.
findings
So extension of time for inspection.
in inspection.
Your Lordship will kindly
Time.
ask them to take inspection on a holiday, Your Lordship, or any Saturdays, Your Lordship, so that a little more time can be given.
Time is extended for inspection of document till 17 June.
By giving 2.5 hour inspections, only 6 documents, my lord. So if this.
No, Your Lordship, that is not correct, Your Lordship. We have given the.
Inspection shall be allowed in any convenient time, mutually agreed convenient time. Suit will appear in the list on 17, bolam na?
Your
17
Lordship,
June.
as per Your Lordship, numerous letters were written, Your Lordship. If we give it for mutually agreed time, Your Lordship, they will never agree to any time, Your Lordship.
Well,
or any-
we'll accommodate. Henceforth,
If it is not done, then documents are to be produced before this court and we'll inspect in the court premises.
Yes, Your Lordship.
By this time, I ensured me.
Deeply applied.
I'm grateful to your lordship. 22. Item number 22.
I appear on behalf of the plaintiff, my lord. We're in the midst of a possible settlement with the defendant. There is a suit in Nigeria which is also
Adjourn to
kindly adjourns it for 4 weeks.
11 June.
Grateful, my lord.
Yes, Mr. Kotari.
11.
Matter item 11.
Item 11.
Yes.
Lordship, I was seeking for an accommodation because Mr. Mukherjee, Sarvpriya
Not this week.
Grateful, Lordship.
I'm for the petition, Your Lordship. My senior is another court, so that's why.
Not this week.
Grateful.
Item number 6. In this matter, I appear for the plaintiff, my lord. On 10th of March 2025, my lord, we obtained your lordship leave to withdraw, my lord. This morning we have received instruction, my lord, so that guys by playing some time, little time, so that we can get ourselves ready, my lord.
My lord, I'm appearing for.
Sir, I'm the plaintiff.
আপনি বলছেন কেন? আর আপনি কথা বলুন, আমি তো বলছি। He is my client, my lord. সরে যান, পিছনে যান, আপনাকে বারণ করলাম, আপনি কাকে বলছেন?
For the plaintiff, argument is adjourned to 9 June, 10 June. Or come in May? Would you be ready within May?
Yes, my lord.
If,
It's a short time, my lord, maybe given, my lord.
my lord, if
Short
it
time.
can be in June, my lord, because I'll also prepare my written notes of argument, my lord.
Do
because
that, but
yeah.
let me hear partly.
My lord, I have to submit. They have already made the submission, my lord.
Plaintiff's argument I have not yet heard.
No, not yet.
Not yet heard. Plaintiff is yet to argue.
Defendant number 2 has completed.
Yes.
I had commenced, my lord. I'm in midst of my argument.
Finish it.
If the short time may be given, my lord.
14th May.
My lordship will kindly, my lord, because I'll prepare my. Your lordship will see the document. It is voluminous. I'm trying to prepare a written notes, my lord, so that I don't take much time in one hearing. It is done, my lord. Lordship will kindly give me some time so that.
Yes, 14th May. 14 days times are giving.
My lord, my lord, vacation is coming, my lord. In that I can use that time, my lord, to prepare a elaborate written notes, my lord.
11 June.
Grateful, my lord.
For arguments, item number 23. Pawan Kumar Tibriwal.
I do appear for the defendant number
Hmm.
1. Mr. Mitro and Mr. Ghosh are making the submission, my lord, on behalf of the
Mr. Ganguly, why one is appearing here? Oh, US, it's okay.
US one.
Yes.
They were making the submission, the plaintiffs. I have already commenced the submission.
Yes, you have finished.
Yes, madam. Mr.
Where is your other side?
Representative of the plaintiff is
Passover.
24 and 25.
My lord, in the last occasion,
Your notes of argument is not here. I'm not able to study it.
I apologize, my lord.
Yes.
On the last occasion,
Where
my
is
lord,
Mr. Lahiri?
he is not here, my lord. May I also say one more mistake on my part? My lord had wanted me to file an application to bring the copy of the Exhibit E on record, because Exhibit E originally was missing.
Hmm.
After we had tendered for examination,
Exhibit E
is the power of attorney given by.
Not very important.
May not be. May not be. My lord, may I hand over the and
Where is your lawyer?
Or my lord, may it be my lord to fix another date in my after going to.
Yes, I have to study your notes of argument.
I have also tried.
Have you served copy to Mr. Lahiri?
I will.
Let me wait. Written notes of argument is filed on behalf of by Mr. Ganguly, the learned counsel for the plaintiff. Serve copy.
অ্যাপ্লিকেশনটা করতে হবে করা হয়নি
Copy served.
The notes? No.
Because I'm studying the brief. I'm studying the record, first thing. Second thing is that this process is incomplete because notes of argument for the plaintiff is not filed.
Yes.
Now it is on record. I have to study a little bit.
Then, my lord, I think in one day I can finish my.
You finish it one day. And if I have a query, I'll put before you both.
My lord, one more thing, my lord, one more indulgence is required. EOS 1 is going on, but that was transferred from the city civil court to here.
Yes.
My lord, I have checked, there is no wakalatnama. After the wakalatnama of that court, that advocate is there in the lower court.
So you have to file wakalatnama.
Yes, leave may be granted to the plaintiff in that suit to file a wakalatnama.
Yes, he.
You file wakalatnama. If any problem is there, I will grant you leave.
No, other than leave, they will not.
Without leave, my lord, they will not.
কি বললাম? Copy served speaks. 8 May for further argument. Full stop. Leave is granted. To whom?
To the parties, my lord. I don't
The
think
parties to file wakalatnama in these pending suits.
my lord will specify US 1 of 2010.
In these giving in liberty. If not on record. To regularize it, to regularize the record itself.
And my lord, leave to file that application. I will file that application.
For bringing in record power of attorney, not needed. I don't think it's very much needed.
I remember, my lord, this was mentioned, and perhaps my lord had already recorded it in order. I'll check out. I'll check out.
Come on the next door with on mention, you can bring it.
My lord.
Just make a mention with no notice.
My lord.
Oblige, my lord. We'll study this.
In fact, my lord, once hearing starts, unless we can conclude the hearing, it's very, very, very troubling also.
Why?
One keeps on thinking about it.
No, unless notes of argument is there, I have to track my thoughts. I have to streamline my thoughts.
Earlier, my lord, what used to happen in High Court, I have seen Justice Rajanath Rai and some of these. The suits will, once the suit is taken, until it is finished, no other matter will be taken in the suit.
No, other matters will be disturbed.
But that way the other matters were getting disturbed.
Yes.
At the same time, it also had some benefit that you were only engaged in that. And you finish it and then take up another matter. Otherwise, it becomes very difficult.
So many matters are there.
Well, on 8, let them finish. I will go through this.
All right.
Give me one more day to ask.
I may not finish on 8th of May. My lord.
26.
You check one thing. Check affidavit of assets. Is it okay? Is it in order or not?
There is only one correction in deposition.
That may be made. That is no issue. But so far as affidavit of asset is concerned, just check it. Whether do you need to incorporate anything more which is missing, or description is proper or not, those are to be checked.
Nothing more to be incorporated.
Sure. Any notes of argument?
My lord, notes of argument, it went as he is the sister-in-law of my daughter. It will be father-in-law. He cannot be sister.
No, that's okay.
Otherwise,
That is no
everything
issue.
okay. Otherwise, everything.
Any notes of argument?
My lord, I have a small notes of 2-page notes of argument. I have just given the history, the details of the heir, and the question numbers where the will was proved.
Property is given to whom?
Is given to the executor who is the younger son.
Oh, let me pass order. Video. চেম্বারে দিয়ে দিয়ে অর্ডার করে দেবো।
That's fine. Let this correction be incorporated in.
কারেকশন গুলো করে দাও। কারেকশন গুলো করে তারপরে দেবে। Make the correction first.
কারেকশনটা করে
একটা কাজ করো, আজকে আমি রিজার্ভ করছি, তুমি কারেকশনটা করে দাও, কালকে করে দেবো। Argument is concluded, reserved for order.
First over matter, item number 23.
Yes, sir. Can also photo.
Now, my lord, on the last occasion, my lord, I was, if I remember it correctly, my lord, I was showing your lordship, my lord, the written statement of the defendant and, my lord, the case, the evidence of the defendant number two. To come back to your lordship's mind, my lord, it's a suit for specific performance, agreement in writing. Now, apropos that, my lord, kindly come to the written statement, the relevant portions, and what, my lord, the defendant has.
Defendant number 1 or 2?
2. 1, my lord, the suit was settled. Mother and daughter. Mother has settled the suit, sold the property or her share in the property. It's only the defendant number 2 who is contesting. Now, kindly come to, my lord, once the written statement, paragraph 7, page 4.
On or about 5th August.
No, written statement of
Yes, para 7. You showed me this part that on or about 5th August 87, when she was
Yes, sorry. On or about 5th August 1987, she was induced by her mother, the defendant number 1, and her advocate Sri so-and-so to sign several papers purporting to contain agreements for development of the said two premises, the actual contents whereof were not disclosed to her in spite of request. This defendant was dependent on her mother, the defendant number 1, and did not have the courage to go against her wishes. This defendant never agreed to sell any portion of the said premises to any of the plaintiffs or the defendant number 3. The defendant number 1, who was managing the affairs of this defendant, sided by her said advocate, compelled this defendant to sign the said papers, purporting to contain the said alleged agreements with against her wish.
You also showed answer to question number 25 of DW1.
Yes, my lord, I shall show you, lordship. This defendant denies that she received any consideration or executed any of the alleged 7 agreements out of her own free will or volition. This defendant states that the alleged agreements are illegal, unconscionable, invalid, not binding on her, and that she has duly avoided the same. Then paragraph 8. She never agreed to sell any portion of the said two premises to any of the plaintiffs. This defendant did not receive any part of the alleged earnest money alleged to have been paid by the plaintiff. This defendant states that she was compelled to sign the said alleged agreement under compulsion of the defendant number 1 and her said advocate. So this is the case of, my lord, the defendant, that she was compelled by her mother and her advocate. Now, apropos this, my lord, kindly once, my lord, take up the evidence.
Evidence to the evidence of
my lord, defendant number 2, I'll tell you, lordship. Mallika Sarkar.
defendant number 2, yes.
Kindly once come to Question number 7. What
Refer
was
to
your-
question number 25.
I'll before that, my lord, may I show your lordship once, my lord?
Question number
7.
7.
What was your age when your father passed away? Nearly 19. But she was not a minor, what I'm trying to show. Next, my lord, kindly come to question number 24 and then I shall go to 25. Are you aware of the fact that the plaintiffs are seeking specific performance of 6 alleged agreements for sale allegedly executed by you in respect of your 2 properties being such and such? From the instant suit, I came to know that they have filed specific performance. Have you gone through those agreements? Yes. For the first time, when the suit came up in the Honorable Court, I got to see the papers at that time. Before this suit came up before this Honorable Court, were you not aware of all those alleged 6 agreements? No. So, my lord, she says that she executed the documents under compulsion of her mother, or her mother compelled her to execute the documents. And here she says that she did not know about the agreement. Did you agree with the terms and conditions?
28 and 25 are contradictory.
Yes. Can you explain the reason or ground for your not accepting the terms and conditions of alleged those agreements for sale? Because my will was not there. I was coerced and was under pressure to sign those agreements. Then they allowed me to go through the papers. They did not allow me to read what is written there, nor I was allowed to show it to any other lawyer. In answer to your earlier question, you have referred to certain persons. Who are they? Kindly omit that. Kindly come to 30. Did you sign those alleged 6 agreements for sale freely, independently, and out of your own volition? No. There was an altercation with Mr. So-and-so when he suggested that I should sign the papers because my mother had already signed them. I said that I wanted to show it to my uncle and to his son, who is also High Court lawyer. On hearing this, the said advocate got very furious. He thumped the table and charged my mother by saying that Mrs. Sharkar, please control your daughter, and said she is not listening to us. We are her elders, and you are all wasting my time. Firstly, my lord, this case is not there in the pleadings. Now, in any event, she says that she was forced to sign. She has, or she had, I'm not very certain, at least at that point of time, she had her uncle and her cousin, both lawyers. No step taken. Not a single, my lord, letter written that.
So your point is she was conscious of the coercion and undue influence.
There was no coercion or no undue influence, my lord. She was fully aware.
Yeah, no, if we take her case, then she was coerced or undue influence was there at the time of signing of the agreement.
Yes.
From that point of time, there was till the filing of written statement, no step was taken.
No complaint. Not a single complaint.
Or no suit for cancellation of any agreement.
Even in this, my lord, in the written statement, my lord, there is no, my lord, counterclaim. There is no separate suit, my lord, for cancellation of this document. She says that she came to know about the agreements, my lord, when the suit was, my lord, served.
So once you have signed it and once you have not assailed it, you are bound by it. This is your contention.
Absolutely. Then kindly, my lord, may I 33, were the draft copies of those alleged agreements for sale handed over to you for your reading or your perusal? No, I was not given anything. to read after signing any copy of the sale agreement? Did you consult with any advocate or legal professional before execution of this agreement? I was not given any opportunity, as I said earlier. Nothing could have prevented her, my lord, from, my lord, issuing letters. She could have done it herself. Her uncle, my lord, cousin being, my lord, lawyers, my lord, that could have been done. That was not done. 35. Who did not give you the opportunity to read those agreements? Non-stop that, I really do not know, non-stop that situation. All of them were there watching me right of the corner of the room with the back of the chair against the wall. I was getting very agitated because there was a very hostile and volatile, threatening kind of atmosphere in the room that you must sign these agreements. Obviously, my will was not there. I was compelled and under duress.
He was not compelled.
Sorry? I presume, my lord, that not will not be there. That's why I omitted. I was compelled and under duress because of my young age.
These should be corrected.
Yes. Then kindly come to 38. Who made this situation of duress and undue things? Mainly it was the solicitor, and in support of my mother being silent, and Mr. So-and-so was angry, the purchaser. Since when do you know Mr. So-and-so? That day from the advocate's chamber on 5th August, when I walked into the chamber, he asked me, do you know who you are here? Then I said no. Then he showed Mr. Tibriwal to me and saying that this is Mr. Tibriwal. That is when we all sit down, and this thing not making me read the papers and not signing them and thumping on the table and raising of voice created a very unpleasant situation, and someone shouted at me, on me, and I am feeling very
Everywhere quashed is written as quashed. That should be corrected.
My lord, I think, my lord, those were...
Anyway, once it has come, once we understand, then
yes,
it will not stand in the way.
42. She is repeating that, my lord, she did not sign of her own free will, and, my lord, she had been forced to sign. Now, as fell from your lordship, even in the written statement, my lord, there is no counterclaim. Even if I proceed on the basis that she knew nothing, she knew nothing about the documents, she was forced to sign, she, helpless girl, could not do anything, could not go to the uncle, could not go to the cousin. When the written statement, when the plaint was served, she files written statement, she does not seek cancellation. Then 43, are your allegations true or false? It is true. It is a fact that I was coerced. By August, some unknown person putting their will on me that you must do this. That was very upsetting, and no one was listening to me. That why can I not take these papers, phone, and show it to my uncle and his son?
This is evidence of an hostile atmosphere. Where she was forced to sign these documents.
Yes.
So in this situation, in this background, your point is that since that was not assayed, there is no cancellation of allegation, or there is no attempt to cancel these agreements. These agreements stayed.
Absolutely. My lord, my submission before your lordship is that existence of the agreement is not disputed. The agreement is there. She says that it was not executed by her out of her free will. But that she has to prove. Now,
then she has waived her objections.
Absolutely.
And these are not avoided.
No.
What are in cross-examination?
I'll come to that. কোথা থেকে বলতো? My lord, the cross-examination starts at, my lord, from question number 77.
Yes.
And my lord, if your lordship is pleased to look into, my lord, question number 82, 83, my lord, she was not a helpless girl. She was studying abroad, staying there of her own. Then kindly come to question number 89. Question number 89. Or 88 onwards.
She visited twice.
Yes. Can you recall for what purpose they took you and to the office of Mr. So-and-so on 2 occasions as deposed by you in 1985? On one occasion, probably my father's own word, and I tagged along with him. And on the second occasion was he wanted to see that my daughter wants to become a lawyer like her forefather was, and what did I need for that? After the death of your father on 30th January 1987, on 5th August 1987, you and your mother put signatures on several agreements and 2 power of attorney which have been tendered in evidence as exhibit in the present suit. Can you tell, did anyone accompany you and your mother from your residence to the office of the advocate on 5th August 1987? I think the driver drove us to the place. All the 6 agreements dated 5th August 87 being Exhibit A to Exhibit F were signed by you and your mother on 5th August in the office of the advocate. Am I correct? Yes, I am not denying that. My signature was taken by coercion. Shown Exhibit A. Have you signed this document? Yes, I was told to sign after my mother. This is my signature, but at page 8, I was told to sign after my mother's signature in the memo of consideration. Shown Exhibit B. Have you signed this document? It is the 5th day of August 1987, and yes, this is my signature. Exhibit C, same. Exhibit D. Yes. 93, kindly come to. Shown Exhibit C at first page, and 7 and 8 dated 5th August 1987. Have you signed this document? It is 5th day of August 1987, and yes, this is my signature at page 7, and this is my signature on the memo of consideration as at page 8. Then, my lord, all the documents were shown. Then kindly come to 97. Kindly look at the power of attorney dated 5th August 1987 in respect of premises number such and such, being exhibit such and such. Kindly look at the last page of that power of attorney where you and your mother have put your respective signatures. But this page, I have not seen this before. This is totally unknown to me. This green paper I have never seen. Kindly look at page 4 of this document. Does your signature appear there? Yes. Then the court, my lord, was pleased to ask question. Is it your signature? Yes. Witness volunteers showing the first page. I have not seen this page beforehand. Then kindly come to 102. Kindly look at the seal of the Register of Assurances. Or ballot 101. Kindly look at the first page of Exhibit J, the same document. It was registered before the Register of Assurances. Is it registered document? I do not understand whether it is registered or not. 102. Kindly look at the seal, the Register of Assurances, Calcutta, on the left-hand side, just after the stamp paper of ₹50 on the first page of Exhibit G. Have you ever heard of the Office of the Register of Assurances? Not then, but today, of course, I know. But by expression then, which period are you referring to? Assuming the time when this paper went to the Register of Assurances, she had to go there. Kindly look at the reverse of first page of Exhibit J. Do you find your signature? Yes. Please encircle your signature in red pencil. She encircles. Then kindly come to 107 or my lord 106 also. Please also mark your signature on page 4 of Exhibit J with blue pencil. She encircles. 107. Can you find out that your mother has also put her signature on the reverse side of the first page of Exhibit J? Yes, my mother's signature there. This must have been one of those blank papers on which I have to sign. This is a new case made out. 107 blank paper comes in for the first time.
What is Exhibit J?
The power of attorney. A power of attorney was executed.
Along with development agreement.
Yes, yes. But that was melodious. Then kindly come to page question 109. Do you find
Exhibit J signatures are there?
Yes, yes. Kindly come to question number 105. (104, 105).
I think there should be a split. 109 should be splitted. Answer is I do not know the person. I do not remember these events. Then a fresh question should start.
Yes, yes. The registered, yes, madam. It can be marked as 109A.
Let it be there because it cannot be splitted right now.
Very well, madam. The registered document being Exhibit J shows that you and your mother put signature on the reverse side of the first page of Exhibit J on 17th August. That is after 12 days from the date of execution of the power of attorney on 5th August. Am I correct? Yes. ওরে আবার জেএনইউ স্টুডেন্ট তো ওই জন্যে
Any question was put on these allegations of coercion? Would you argue whether it was challenged or not?
I'll check it up, my lord. The documented opere.
Have you challenged it or not in cross-examination?
Kindly come to question number, my lord, the evidence of 20th February 2024 before your lordship. Kindly come to question number
20th February
2024. 205, kindly come to. Did you write any letter to the plaintiff or any of them at any point of time alleging that you had some time put your signature on many documents as alleged by you? There was no such opportunity because soon after my signatures were taken, none of the papers where my signatures were put on was given to me. Such stand, I do not know what I signed on. Question repeated, answer is no. Then kindly come to 207. Kindly look at your answer to question number 30 and 34. Between 97 and 1987 and 1996, when the present suit was originally filed, did you consult any lawyer regarding the documents on which you put your signature in the year 1987? I was to know any of the lawyers, namely my cousin who was a lawyer, that such a thing had happened. Apart from informing the person whom you have just now referred, did you take any other step in this regard? At that time, my mother was looking after the matter. So I could only tell her that we need to talk with somebody, and figure out what was going on, because the tenants were misbehaving with us and stopped payment of rent. So the only thing I told my mother that she needed to refer the matter to a lawyer who could help us out.
Come to 214.
My lord. Did you ever lodge any complaint before any authority alleging that you had you were compelled to put your signature on various documents as alleged by you in a written statement, in your written statement filed by you in the present suit? After having signed the paper in 1987, I made an attempt in 1989. I went to the local police station to say that I had some legal problem. Then they said, please bring guardian along with you. I did not put whatever it is. Did you ever lodge any complaint before any authority alleging that your mother had induced you to sign? Since she was my mother, my lawyer had advised me not to file any complaint against her. So she approached lawyer. 217. So I take it that between 1987 and 1997, you never lodged any complaint before any authority or person alleging that your mother had induced you or compelled you to sign blank papers in 1987. Am I correct? Say yes or no. There was no opportunity to do so.
There was an opportunity.
It should be. I presume, my lord, it would be no. I presume, my lord, I give the benefit of doubt to the witness, my lord. I presume that she said that.
To Mr. Dotto. So in this part, you challenge the evidence or challenge the pleadings. The allegation of coercion, undue influence was challenged in these questions. Yes.
Yes. Kindly once, my lord, come to 210.
210. Did you write any letter?
To the plaintiff or to the advocate to disclose any of the documents which was signed by you before filing of the written statement or inspection of the said documents. I was advised by my lawyer to do so.
But not done.
Not done.
What is your argument on point of limitation?
Limitation, my lord, refusal, it comes from the date of refusal, my lord. Because lordship is aware, my lord, that I shall show that in a suit for specific performance, if no date is mentioned, or my lord, if the time is not the essence of the contract from the date of refusal. And the refusal came later.
In 222, we challenge that evidence. You raise this issue of undue influence.
Yes.
She was contradicted and she says, no, there was undue influence.
Yes.
Yes.
May I come back on the next day, my lord?
Notes of argument?
I shall try to.
Heard Mr. Mitro, the learned senior counsel for the plaintiff in part. Adjourn to 19th May for further argument.
Okay.
Witness action. Item number 27.
Lordship, I appear for the plaintiff. My witness is there in court, my lords. The re-examination, the cross-examination was going on.
Mr. Sengupta is leading me in the matter, my lord. If my lord passes the matter over for a few minutes.
28.
28.
The executor was in the box, my lord, and my lord, on the last occasion, he had not produced the original of the death certificate of the propounder, of the testator. My lord, that he is there, my lord, it can be examined.
P-A-M-O-G-H-N-A. G-U-H-A-N-E-O-G-I.
Are you in a position to produce the original death certificate of the testator today?
Yes.
Who is your other side?
Lord, it is
PLA.
uncontentious, yes, non-contentious. Lord, the attesting witness has been, Lord, examined, and the executor
He's
was being
pleaded to
examined.
two.
Yes, executor was being examined. Only the death certificate was left. Executor.
Copy, just a copy.
And, other than this, my lord, he has already deposed that he is aware of this.
Evidence is
procedure.
over.
Yes, ma'am. I believe, my lord, this was only required.
PW2 is examined fully and discharged. Second May for argument.
Very good. We'll carry a notes of argument as well on that day.
As you like.
Very good. Great, thank you.
Item. Item number 29.
I'm appearing for the plaintiff.
Who is your other side?
My lord, my witness was in the box and I'm to complete the panel. Chief.
What we are both is concerned, my lord. They have to obtain the certified copy of the depositions, my lord.
P-Y-A.
Let her be examined. Examined in chief be over first.
P-H-R-A.
We'll not begin cross-examination today. That's what you want to say.
The previous matter is saying, my lord, that we have to obtain the certified copy of the deposition to argue, my lord. If it can be, my lord, 2 weeks since, my lord, then we can obtain the certified copy.
Need not be. You check it.
From the records. Great.
Don't delay this matter. I will check the record. If anything I needed to, or if any explanation is needed, then I will give you opportunity. Otherwise, I don't need to give it, or don't need to hear you.
Well, before the witness starts, may I indicate, my lord, on the last occasion?
Corrections.
No, my lord. There is one document, rather a set of documents, similar documents, which I wish to produce before this court, for which I have disclosed the document, given inspection of the document, and my lord, I have also filed an additional judge's brief. My lord, I've prepared a they have taken inspection of the original documents without any dispute. My lord, no letter issued
These
as
are
well.
these documents.
My lord, the documents are already on record, my lord.
So why? What is this?
This is a supplementary affidavit only for the purpose of affirming the same and stating the documents, my lord.
So the last day indicated that it should be by way of an application.
My lord,
Because
I
the
shall indicate.
documents not relied upon in the plea.
My lord.
Then it should be by way of application.
My lord, I will indicate. My lord, my lord, this is a proceedings not under the Commercial Courts Act, but under.
You file application.
My lord,
Otherwise, I won't allow you. I'm telling you.
I have taken out a judgment to indicate that for the.
Without any application, I won't allow you to file this.
My lord,
File
that is why I'm filing the supplementary. My lord, the judgment indicates
All
that.
right, produce it.
Much obliged, my lord.
I will pass the necessary order.
My lord, I was only requesting because, my lord.
Whatever do you want to do, you proceed. I explained you what you have to do. You may now, you are at liberty to proceed in your own way.
My lord, I do not wish to proceed in a manner which will render the.
You come with an application. If this is not disclosed in the plaint, then we have to hear it. He may have something to object.
My lord, these documents were produced, given disclosure was given to them. They did not object, my lord.
File the affidavit.
My lord, I have filed the affidavit. My
Do
lord,
this.
If my lord so wishes as well, my lord, I have taken out.
I have expressed my mind.
Indeed, my
I have expressed my wishes. Don't put something on me.
Very well, my lord. Very well. My lord, in that case, my lord, if so necessary, I shall take out an application as well. My lord, there is no issue with regard to not taking the or rendering something that would render the process completely infructuous. My lord, the witness had come down for 3 days, and we were to come.
Why have not you done this earlier? I have told you.
I was that is why I had given the disclosure earlier. I had given the disclosure early April. My lord, they had not objected. I was under the impression that by
Did you file any application or not?
No, my lord.
Or would you
I did not.
proceed with the evidence?
My lord, I haven't placed it in the evidence as well yet. Because, my lord,
What will you like to do today?
My lord, I can proceed with the examination of the.
Proceed with then.
With the remaining portion.
Yes.
If required, I shall come back with an application. I shall complete. So far, I have done. I shall complete disclosed documents. Within a deposition.
हिंदी में कोई बोलने वाला
लास्ट दिन
इंडियन इंग्लिश
kindly may I take my lord's leave to show the witness exhibit D. Exhibit. What do you have to say about the contents of this letter?
सही है करेक्ट है
This question was asked possibly.
My lord, it wasn't. My lord, as Mr. Basu had done the cross-examination on last occasion, sorry, chief, examination in chief on the last occasion, and my lord, at that stage, my lord, I had gone through, so I'm trying to rectify. But the document has been marked otherwise. Yes. But exhibit E টা দেখাবেন exhibit E টা দেখাবেন exhibit E for elephant after you had issued this letter, what steps did your advocate take in respect of this letter? I will explain করে দিন না
उन्होंने जो सुधा काकरिया जी हैं उनको लेटर भेजा
The defendant correct. Did did the defendant receive this letter?
नहीं.
After the letter was issued to the defendant, by what means was this letter sent to the defendant? Hello. Answer has gone in. Well, may I just ask one more question on this?
Post से. हाँ, speak post से.
What transpired after the post was sent to the defendant?
वो लेटर उन्होंने एक्सेप्ट नहीं किया और आ गया था मेरे लॉयर के पास.
She had not accepted the letter and the same applicant
लॉयर.
to my
On what basis can you indicate that the letter was returned?
क्योंकि वो लेटर जब आया था उन्होंने बोला था वो क्रॉस होके आया था और उन्होंने देखा नहीं था लॉयर ने.
My advocate told me that the letter and they have not accepted.
Lord, may I please the plaint? But my lord, I shall be taking out an application. So, if my lord permits, I can finish that portion.
Mr. Das, please proceed with the evidence or stop it. You are not arguing a case.
In that case, my lord kindly grants me a date. I'll come back.
She is PW?
PW1, my lord.
PW1 on recall is partly examined in chief.
No, not my lord, or not on recall. She's the first witness.
Okay. Examined in chief in part. Further examination is deferred to. When will be able to come? In June or May?
My lord keeps it in June, my lord. And my lord, I would request for a few consecutive dates so that the chief and cross can be concluded, my lord.
Examination adjourned to 11 June, 12 June, and 13 June, respectively.
13. Thank you, Mr.
My lord,
Wait for it.
my lord, may the witness step.
Twenty-seven.
Item 27.
Lordship, 27, I'm for the plaintiff. My witness is there, my lords. It's the PW1 cross-examination was going on. Mr. Jointo Sengupta was doing the cross-examination.
Where is Mr. Sengupta?
That is on legs before another court, my lord. My lord.
Then you have proceed.
Yes, my lord. This witness. Who is occupying the current premises, my lord? Mrs. Witness, who is occupying the premises being 5A and 5B Chaurangi Lane at this present moment?
Chaurangi Lane.
Chaurangi Road.
Chaurangi Lane.
Chaurangi Lane, yes. At this present moment.
5A Chaurangi Lane, is occupied by various occupants, flat owners. There are a lot of flat owners who are staying there. By various flat owners who in 5A Chaurangi Lane. And 5B Chaurangi Lane, there are no flat owners. It's not occupied by anybody right now. It is under our possession, but it's not occupied.
It is under.
This witness were either of the premises ever in your were either of the premises your residential address at any point of time?
Yes.
Can you recall as to when?
Since when?
Yes.
I have been residing in 5A Chaurangi Lane since a very long time. More than 25 years.
Can you give an approximate date?
Can you remember any date?
Since I can't remember.
I can't remember any date.
Since 2000 or maybe earlier.
This witness, before 2008, what was your nature in the premises?
What was?
What was your nature as occupying the premises? An occupant in the premises?
What was?
Nature of occupation on the premises, whether leasee, tenant, owner, or whatever that might be.
Owner.
Prior to?
2008.
Prior to 2008.
Yes.
As owner.
Yes.
This is witness on the previous date you had deposed that there were certain that the partners or any of the partners of the plaintiff partnership firm were tenants of the premises. You were to check on for the next date. Have you checked on this?
No, I could not find the paper for that. It's a very, very old date. It is a very old date. Before 1986, 88.
This witness, do you recognize one Rajkumar Sajnani or one Vandan Sajnani?
Certainly, yes.
Can you tell me as to who they are?
They are one of the flat owners who own a flat in the premises number 5A Chaurangi Lane.
When did they enter into such agreement?
I don't remember the exact date, but it should be between 1996 and 2006. I will give you the correct date, but right now I don't have it.
If I take you to page 112 of your judge's brief of documents, this would be an agreement that you have entered into, the plaintiff
Yes.
entered into. Can you kindly take that agreement, please?
Sure.
My lord, if the witness can take PD 8 of the judge's brief of document.
Do you want to produce any original document?
But that is with them. So.
That is not an original document.
My lord, that's the plaintiff's documents anyway, my lord.
Show the document. It is not if it is not exhibited.
My lord, just to recollect, my lord, just to revive their memory, my lord, not to exhibit.
Yes. Rajkumar Sajnani and Vandana Sajnani entered into an agreement with Capital Construction Company on the 17th September 1993.
Mrs. Witness, who had signed this agreement on behalf of the plaintiff?
On behalf of the plaintiff?
Yes.
One of the partners of the plaintiff, Mr. Rajendra Sarup Agarwal, my father, had signed the agreement representing the plaintiff.
At that moment, who were the other partners of the firm?
A little bit loud.
At that moment, who were the other partners of the firm?
In 1993, my father, Rajendra Sarup Agarwal, and my grandmother, Omvati Devi Agarwal, were the partners. Devi Agarwal.
My lord, if my lord, Mr. Sengu.
Mrs. Jain, do you know anybody by the name of Munna Agarwal?
Yes.
Munna Agarwal. Who is Mr. Munna Agarwal?
My father.
Your father?
His pet name, home name, nickname.
His nickname is Mr. Munna Agarwal. So Munna Agarwal is also known by the name Rajendra Agarwal or Rajendra Swarup Agarwal. Am I correct?
Yes.
I suggested to you that Munna Agarwal or Rajendra Swarup Agarwal was the caretaker of subject premises number 5A and 5B Chaurangi Lane at a given point of time.
Caretaker.
Caretaker.
I am not aware. I am always aware that he was the owner.
I suggested to you that you have already deposed that Munna Agarwal, alias Rajendra Swarup Agarwal, was a tenant under Usharani Rajgharia.
Usharani?
Rajgharia.
Yes. Yes.
Yes. So I suggested to you that your answer to the earlier question that Mr. Rajendra Swarup Agarwal at all material point of time was the owner of premises number 5A and 5B Chorangi Lane is incorrect and false.
He was the owner, since I know, in 1986. He entered into an agreement for sale. Before that, he was one of the tenants before becoming the owner.
He was the
And he eventually bought it.
answer. Did the plaintiff make any payment to Usharani Rajgharia upon the alleged agreement of 23rd June 1986 having been purportedly executed?
On that day, on 23rd June?
Immediately upon execution of the agreement.
Yes. Can I see the judges?
I'll call upon you if need be.
On the day on 23rd June.
23rd June bowling. Immediately there.
No, I have to see the document and then recall it.
Shown the document. 23rd June 1986 agreement. Exhibit.
First volume 1.
It is Exhibit A, pages 11 to 29 of the Judge's Brief of Documents.
Oh.
23rd June 1986. The plaintiff paid Usharani Rajgharia. Plaintiff paid Usharani Rajgharia the sum of rupees 1 lakh.
Now you may close the document. What was the mode of payment of the said alleged sum of rupees 1 lakh purportedly paid by the plaintiff to Usharani Rajgharia?
I will check the document.
Whether it's by cash or by check or in whatever way this was paid.
I will have to check once.
You are the partner of the plaintiff, so you must be aware of these things. You are coming to depose on behalf.
No, I was not the partner that time.
Might be, but you are
Yes.
you are here to depose on behalf of the plaintiff. You
I
must
know.
know this much.
I have been answering all the questions. There are so many questions, so I can't recall everything.
Very good. Sure.
I'll check.
The answer হলো তাই যাবে. The very answer will go.
It was done by an account pay check.
Was this purported check of rupees 1 lakh allegedly paid by the plaintiff to Usha Rani Rajkaria encashed by Usha Rani Rajkaria?
Pardon?
Was this check encashed? Did Usharani Rajgaria encash this check?
Yes.
Have you produced any document? Now you may close the judge's report. Have you produced any document in the instant suit showing encashment of the said check of rupees 1 lakh allegedly paid by the plaintiff to Usha Rani Rajgaria?
I can't recall.
Shown the judge's brief of documents. Please.
Corrections.
1 lakh rupees was paid. Now it was encashed. Must have been encashed. I can't see it here. I can't find it.
I suggested to you that there exists no document showing the encashment of the check, alleged check of rupees 1 lakh purportedly paid by the plaintiff to the said Usha Rani Rajkaria.
This check was not encashed. This is his statement. Do you agree or disagree?
Disagree.
Have you produced any document before this honorable court showing the encashment of the check of rupees 1 lakh allegedly paid by the plaintiff to Usha Rani Rajgaria?
Can I check the second part of the judge's brief of documents?
থাকলে তো দেখাও।
Yes.
Thank you.
On page number 42 of volume 1.
What is this document?
This is the memo of consideration which Usha Rani Rajgaria received throughout her time from Capital Construction Company. And the first installment was 1 lakh. Which she has also signed on. She has accepted this.
I suggested to you that this memorandum of consideration does not demonstrate the encashment of the alleged sum of rupees 1 lakh paid by the plaintiff purportedly to Usharani Rajkaria?
How will I know whether she
It's a
encashed?
suggestion, madam. Either you
Okay.
agree or you disagree, and thereafter you answer.
I disagree.
Very good. I suggested to you that the purported signatures indicated by you forming part of this instrument appearing at pages 30 to 51 are not the signatures of Usha Rani Rajkaria.
I disagree.
Well, I'll continue the next.
Partly cross-examined. This she is DW.
She's
PW1, my lords.
PW1 is partly cross-examined. Adjourned to 11 June.
Grateful.
Grateful.
Thank you.
Grateful, my lords.
Grateful.
What happened to you?
I was rushing. I was on legs before Justice Mukherjee or in the Mukherjee. So
From that
23 to here, my lord.
big leap.
Big.
I understand.
Item 30.
And for the plaintiff, my lord, Mr. Dhruvo Ghosh was cross-examining my witness.
No, no, only Kundo. Only one small correction. 107, it should be dependent, not definite. Yes. Madam, may I proceed? Mr. Poddar, are you familiar with the signature of Dr. Debol Sen personally?
No, my lord.
Would I be correct to say that the defendant number 3 has never interacted with the plaintiff prior to the filing of this suit?
That is correct.
Would I be correct to say that the plaintiff has never in writing challenged the status of the defendant number 3 in the said premises?
My lord,
Prior to filing of this suit.
my lord, he is a trespasser, and I have filed a case against him to vacate this thing in 2021.
I put it to you that the defendant number 3, now I put it to you that you have not shown any document to show that the defendant number 3 acknowledged either the Craigs, C-R-A-I-G-S, Craigs, capital C, nor the plaintiff or anybody else as his landlord. Would I be correct?
Well, may the question be repeated once, my lord? May the question be repeated once.
He has understood.
My lord, because maybe he has understood, but this is totally against the case that has been made in the written statement.
You have not shown any document.
You have not shown. Yes.
You have not shown any document to show that the defendant number 3 acknowledged either the Craigs or the plaintiff or anybody else as his landlord. Would I be correct?
Your lordship will be pleased to see paragraph 8 of my learned friend's client's written.
Mr. Ghosh, let the question be asked. Because
Subject
we are
to
not
objection.
subject to objection. That can be done.
Subject to objection.
But right now, I cannot adjudicate whether this question is right or not. Subject to objection, it can be definitely.
Subject to objection, my lord. Obliged.
This is exactly what I'm asking him. I don't know anyway. But he should specify his objection.
Then things would be delayed.
Very good. Let him answer the question.
May you repeat that question?
I put it to you that you have not shown any document to show that the defendant number 3 acknowledged either the Greeks or the plaintiff or anybody else as his landlord. Would I be correct?
He is a trespasser.
Whether he recognized anyone as a landlord.
No, the question is, have you disclosed any document?
Disclosed any document?
I have disclosed the deed of conveyance in record.
Try to understand the question. Repeat the question.
I put it to you that you have not shown any document to show that the defendant number 3 acknowledged either the Greeks nor the plaintiff or anybody else as his landlord. Would I be correct?
Whether defendant, try to understand, whether defendant number 3 disclosed any document.
No, whether he has disclosed any.
Whether you have disclosed any document to show that defendant number 3 has recognized the plaintiff or any other person as landlord.
My lord, he is a trespasser.
Have you disclosed any other document? Understand the question. He may be trespasser, but you try to understand the question and answer it.
I have disclosed the deed of conveyance in my record. I have not disclosed any. I have no knowledge why he will not accept Craig or
any document.
He has said no, my lord.
No, all right.
No, but I have disclosed the deed of conveyance.
This will go.
This was answered. Let him say good. Let it go down what he said. I have no.
On objection.
The objection is there's no. I don't know why my lord. I'm asking him whether he's disclosed a document.
If your lordship kindly goes through paragraph 8.
Mr. Ghosh,
yes,
if I am not here to compare every part of pleading with every part of question, and especially this is cross-examination.
As has followed from your lordship, subject to objection, we'll argue at the time of argument.
Sorry, no, answer to he galo.
Answer to last time. No, but I have disclosed deed of conveyance.
Yes. I put it to you that even from prior to the deed of conveyance, which you are referring to, the defendant number 3 has been in open, visible, and continuous possession of the said premises since 1994. What do you say to that?
I disagree.
Please have a look at your answer. No? 63. To question 66. Question 65 and question 66. I put it to you that your answer to the instant question is contrary to the evidence you have already given. What do you say?
My lord, I have said that he was there before 1998. There is nothing of 1994.
So do you know when the defendant number 3 started occupying the premises? Before 1998, as you have said in question 66?
My lord, I have mentioned that the flat was given to Mr. O.P. Puri, Mr. Joshua, and Trinkas. Mr. O.P. Puri, Mr. Joshua, and Trinkas. I would not know when they
Who of them handed over the premises?
when they have handed over the premises, and when did they allow him to stay?
No, Bolche, I do not know.
When did they allow him to stay?
I put it to you that the defendant number 3 has been in occupation of the portion of premises number 87 Park Street since 1994.
I beg to disagree.
Let him finish.
Since 1994 and such possession has been hostile to anybody else.
I beg to disagree.
That's it. I further put it to you that the suit that has been filed by the plaintiff, the instant suit filed by the plaintiff, is not maintainable and barred by limitation.
I beg to disagree.
I further put it to you that the plaintiff, no, I want more question. I further put it to you that the defendant,
Mr. Ghosh, you should stop now.
2 more questions. The defendant number 3 did not receive the letter dated 31st October 2019 being Exhibit 3.
I would have to.
That letter I showed you on the last occasion.
I have got to see the.
Come on the next day. Come on the next day.
Only one question, last question. Say I'll have to check, or I have to see the record, whatever.
I have to see the record.
I further put it to you that the plaintiff is not entitled to any of the reliefs claimed in this suit.
I beg to disagree.
He is DW.
PW1. PW1.
PW1 is fully cross-examined.
Yes.
On recall. On recall.
Any other witness to be examined?
No, my lord. We do not.
So should I take for argument?
No, my lord. Their witnesses to come.
PW1.
Mr. Bose. Defendant number 3 who now will have to be very in this
You are defendant number 1. 1 and 2. PW1 is cross-examined in full in recall on recall and is discharged. Fix.
My lord, your lordship will fix it after the vacation any day, but not for the witness hearing because I'll have to check up. I was a late entrant in the sense that I'd filed my written statement, but I was not intimated about the hearing of the suit. The suit proceeded. The witness of the plaintiff.
I am fixing for witness action because it is already in for witness action. Let it continue.
Yes.
If
what further because in the event.
In that case, I will fix another date for argument.
In the event that the other defendant has given some evidence, I was not there for that evidence. Then I'll have a right to question them. But I most probably will not. But I just want to be sure lordship keeps one date and then next day we'll come.
Fix 16 June for witness action.
No, my lord, if my learned friend is to decide as to whether he'll cross-examine Mr. Bose's client, witness or not, for that, if your lordship would be pleased to fix this side.
Witness action, only witness action.
Then you will bring your witness on that day. Then Mr. Ghosh is also to bring his witness on that day so that we can.
For witness action, I'm not mentioning which witness is to be examined or cross-examined.
Yes.
All right.
Very good.